Good afternoon, and thank you for joining us today. I would like to welcome you to part one in FortneyScott's Workplace Legal Compliance webinar series entitled EEOC and Trends in Employer Readiness. This webinar will be recorded. Today's presenters are FortneyScott attorneys Nita Beecher, Leslie Silverman, and Sarah Mugman. I will now turn the program over to Nita to start the webinar.
Hi, everyone. We're excited to be with you today. This is the first in a series of 4 webinars trying to get everybody ready for the fourth quarter and moving into 2026. Let's go to the next slide. I think all of you that are here know us as FortneyScott. We're a Washington, D.C. law firm. Our specialty is the Department of Labor, EEOC, National Labor Relations Board, and we do everything that's covered by those agencies and more. And I would like to, at this point, recognize and have my colleagues Leslie Silverman and Sarah Mugman introduce themselves to you. Leslie?
Hi, I'm Leslie Silverman. I'm a shareholder here at FortneyScott, and we're talking about one of my favorite subjects, or least favorite subjects, depending on the day and what I'm dealing with. But the EEOC, I was formerly a commissioner and the vice chair there, and I've been back in private practice for many years now, and have to talk about it.
Sarah?
So I'm Sarah Mugman. I am an associate with FortneyScott, and I have a general experience with advising organizations to ensure compliance with non-discrimination laws at the federal level.
Great. Well, guys, it's great to have you with us. Let's go to the next slide. But before we start with the agenda for this one, I wanted to let everyone know that our next webinar, which is in October, it's going to be a review of compensation decisions under the governing legal standards and the Trump administration's enforcement priorities. That webinar is going to be on October 23rd. But now we're going to turn to this webinar and our agenda. First of all, we're delighted to have you all with us. We're going to talk about where the EEOC is now. We're in the 9th month, basically, of the Trump administration 2.0. We're going to talk about guidance and regulations from the EEOC, talk a little bit about the disparate impact executive order. Primarily, we're going to focus on what the EEOC's priorities are because we're about to get a quorum, we believe, and then finally what to expect moving forward. And with that, with the next slide, we're going to kick it off on the status of the EEOC, and I'm going to turn it over to my colleague, Leslie.
Nita. Okay, next slide. So
not quite yet.
Here's where we are. So the EEOC is supposed to be a 5-member commission where the president appoints and the Senate confirms the commissioners who serve consecutive 5-year terms, with one expiring each summer and one rolling off or being renominated, and no more than 3 of one party. Now, currently, you're seeing 3 faces there, but only 2 of those faces are on the commission. We have Andrea Lucas, who's in the top left corner. And Andrea was originally appointed to the commission by President Trump in his first term. And then on the first day of his second term, he made Andrea the acting chair of the commission. The other current sitting commissioner is at the bottom of the screen, and that's Kalpana Kotagal. And she is a Democratic appointee who joined the commission in 2023. The third and maybe less familiar face of those of us, who follow the commission is Brittany Bill Panuccio. And President Trump nominated, I'm going to call her Brittany just so I don't, till I get used to her last name, back in May. And in July, there was a Senate Help Committee former hearing about Brittany, and she was voted out of committee. And she is awaiting confirmation, which reminds me, I should have said that Andrea Lucas was confirmed again for her second 5-year term this last summer. So she is on the commission and she is the current acting chair. the way the Senate has worked usually for nominees is they have to wait through this long cloture process, but they recently changed it. I think they're calling it the nuclear option. I don't know how many nuclear options we have, Nita, but now they're talking about confirming Trump nominees in bulk. And they're going to do a group, and we're anticipating that Brittany could be in the next group or 2 groups from now, but that she would be confirmed through that process. So wanted to mention that. Also, the EEOC has another big political appointee position, and that's also has to go through the confirmation process, and that is the general counsel. They have an acting general counsel there right now. That's Andrew Rogers. He's actually waiting for confirmation to go over and be the head of wage and hour at Department of Labor. So the GC spot is open and there's no nominees for that spot, but that's not super unusual. Sometimes the EEOC chair also acts as the acting GC. That happened during my time with Carrie Dominguez, and she wasn't even a counsel. So we'll wait and see, but you know, they may or may not get a general counsel. Next slide. Okay, so there's only 2 commissioners on the commission. To have an actual quorum for the commission, you're supposed to have 3 commissioners. There isn't a full commission or even almost a full commission because President Trump had fired 2 of the Democratic EEOC commissioners at the beginning of I think the last week in January. So the absence of a quorum is not something unusual for the EEOC, and they can deal with a lot of the issues through delegating their authority to vote and do different things, take official actions to others within the commission, and that has what they have done. But they can't vote on things. They can't intervene in certain cases. They can't bring cases that have new issues. And the best way to think of it is anything they voted for, guidance, regulations, things like that in the past, they can't take down, because if you voted, you can't unvote if you don't have a vote. So those are some things to keep in mind. Now, for those of us watching EEOC and familiar with them, then we're probably familiar with Acting Chair Lucas by now. I've said this before in our podcast, I'll say it again. Excellent communicator. This person does not generally hide the ball from those folks. Go ahead, Nita.
I just want to mention one thing that is interesting about Lucas, and I think she's followed the Trump administration pretty much to a T, as we know, and we'll talk a little bit more in detail. But one thing she mentioned in the hearing that she had is that the EEOC is not an independent agency, and I think Leslie, you and I we have talked about this a little bit. And why is it that the EEOC is, I mean, it's quasi-independent, I believe, is how people think of it?
Wow, Anita, that is there'd be a long answer to that, but it started off more independent. Then it became quasi-independent when it took over the ADEA and the Equal Pay Act from the Department of Labor. And over time, it's become less and less independent. And so it is technically an executive branch agency. So,
which means it's much more likely that the lawsuit that Jocelyn Samuels has filed to try to get her job back, she's probably not going to be successful then.
It seems unlikely, that and the fact that the statute, the way it's written, it just doesn't have the protections of some of the other statutes. So yeah, it seems unlikely. That being said, no one ever envisioned a place where we'd have commissions and the same president would appoint all the members or terminate them. So you know, we're at a different time. This is not my EEOC. This is, you know, a whole new situation. So getting back to Andrea's communications skills, on day 1, she issued a press release and she spelled out her top priorities. And if you were to look at that press release today, you'd say, yeah, that's what her priorities are. And those are the things she's working on. She's been very clear about that. And if you want to catch up with her, she's often does interviews, she does podcasts. She has a lot to say. And I'm going to have some direct quotes from her today because I think she says it best. And if you want to know what EEOC is doing, you got to look at the chair. Because of the way it's structured, the chair has the say at the commission. You know how they have that strategic enforcement plan where they put all their issues? Have we been following that lately? No, because the chair really has a lot of control at the commission. So I think that's important to know that. Now, she's the acting chair. Will she be the chair? Is somebody else coming along? That is unclear. I suspect that she'll either be chair or acting chair. But we just have to wait and see, because President Trump could have made her chair, but he hasn't so far. So moving on, we wanted to kind of set the stage, which is that everything the commission is doing is seeking a change in culture. And what we're going to see and what we are seeing, and this is a quote from an interview that both Nina and I have listened to multiple times with her, with the Daily Caller, but she's made it very clear that to make the changes she wants to see in the culture, you have to go after the elite institutions, because that is how you're going to get change. So you're seeing elite universities, elite law firms, elite consulting firms, and all those kinds of Fortune 500 companies. So for DEI, Lucas would blame those folks for setting the culture that of DEI that this administration does not agree with. And I'm not saying those are the only places they're going, but it's a very important aspect of how they are enforcing the law and making a difference. And I will say it's not uncommon. When I worked on the systemic initiative at the EEOC, we knew that if we wanted to drive change in an industry, we'd have to pick a company and others in that industry would take notice. So the elite part is a little bit different. We didn't say the top one, and who's to say? So next slide.
Before we go to that, Leslie, let's just stay on that slide just for a second. I think it's really interesting. A couple of things I want to just reinforce. One, this was her positions. She's not changed. Her positions, and we'll talk about that in a minute, were the same when she was during the Biden administration as they are now. And I think it's important now she has the power to move forward with her positions, but she hasn't changed and she's been very clear. I think that's a really good point. Okay.
And she set the groundwork for a lot of the things she was doing through commissioner charges and other things. And if you want to see where Andrea was several years ago, she literally issued an op-ed within 24 hours of the Students for Fair Admission decision being issued, and talked about DEI then and there. So again, does not hide the ball, this one.
All right, so the next slide really is just, we're getting ready to talk about guidance and regulations. We have just, as you all know, EEOC generally does not have the authority to issue regulations, but they did when Congress tells them to. But let's first start with harassment. And so Sarah, can you talk a little bit about the harassment guidance for us?
Of course. So as Leslie has established, once guidance has been voted upon with a majority, it can't be revoked without a majority. So one particular guidance worth mentioning today was issued back in April of 2024. So this guidance had defined sex to include sexual orientation and gender identity. So the guidance further provided that repeated and intentional misgendering of an employee or denying an employee's access to a bathroom consistent with their gender identity could constitute sexual harassment. At that time, Acting Chair Lucas, who was at the top point was commissioner, voted against that guidance, issued a dissent addressing her opposition to this expanded definition of sexual harassment. So although Acting Chair Lucas has been unable to revoke this guidance, a federal court in Texas had vacated portions of the guidance a few months ago, really concluding that the EEOC had exceeded its authority by defining sex beyond just male and female. And in response, the EEOC has updated the guidance on its website, labeling and shading out the portions that are now unlawful based on this Texas decision. And we also anticipate that once a quorum is restored, that this guidance will be reviewed and reissued.
Yeah, and I just wanted to jump in on that. So as Sarah mentioned, portions of the guidance are like shaded so that you know which ones are are an issue. It actually has a savings clause, as do a lot of guidance and regulations these days. But it's if this is something you use sometimes or want to see where the commission is, I would download it to your computer if you have it, if you're using this, because it is going to go away. Once the commission votes to rescind it, the guidance will probably come down, and it's going to take a while to get one back up because it probably has to go through notice and comment again, and then it has to go through the OMB. And that process is not necessarily a quick process. And I'm not also entirely convinced that it'll just be the shaded portions that come back different, but we'll have to wait and see on that. And let me just add that, I think that, whether or not the guidance is up there, we do have Supreme Court decisions that go way back that, that talk about that may protect these issues regardless of if, even if they take it out of this guidance. So.
Leslie, before we go to the next slide, I just want to say you're right about not wondering how long it'll take to get new guidance up, because they had initially the harassment guidance. It went back to the Obama administration and they couldn't get it done until Biden came in. So
I kept thinking that, yeah, it
you're
sat
right.
at OMB through the whole last administration. A lot of people went back and were looking at, what preceded it, the old guidance and things that, Hy Feldblum and Vicki Lipnick had put out, which they put into the guidance.
All right. Well, the next one, as we said, we are talking about the regulations as well for the Pregnant Worker Fairness Act. That was another, it was passed under the Biden administration. The Congress had directed the EEOC to actually issue regulations on implementing the new PWFA. There was a section, they defined pregnancy, childbirth, and other related medical conditions as including abortion. They also required employers to accommodate purely elective abortions, and a Fifth Circuit Court of Appeals just upheld the district court decision directing EEOC to revise those PWFA regs. So again, as Leslie mentioned a few minutes ago, once they get a quorum, they will have to go through notice and comment, as these are obviously under the APA. She also, Lucas did issue a dissent at the time these regulations were issued over the abortion decision. One other thing real quickly, we didn't put it in here, but there was another issue about the PWFA regulations. They were passed along with a whole bunch of other things when Congress could vote remotely because it was in the middle of the pandemic. And Texas, the state of Texas, as an employer, had raised an issue and said that the PWFA regulation, the PWA Act itself was invalid for that reason. The Fifth Circuit said no. So it is still in effect at this point. And so that's where we are on these regulations. And I think, Sarah, if we go to the next slide, one of the other things, one of the many executive orders that has been issued by the president is on disparate impact. And I think you're going to give us what that might, how that disparate impact executive order might impact the EEOC.
Of course. So just a few months into this current administration, President Trump had issued this executive order related to disparate impact theories, really directing all agencies, including the EEOC, to deprioritize enforcement of any statutes or regulations that involve disparate impact liability. That executive order also instructed Acting Chair Lucas to assess all pending investigations, civil lawsuits, consent decrees, and positions taken in ongoing matters that rely on disparate impact theory, and to quote the executive order, for her to take appropriate action consistent with the president's order. Now, disparate impact is written into Title VII, so the executive order cannot override that statute. So despite practical challenges for individual litigants to pursue these types of claims. They technically can do so under Title VII, but more importantly to note is that disparate impact claims may also be pursued under certain state or local laws as well.
Yeah,
Leslie,
and I
go
was
ahead.
going to add, I mean, the government often is more likely to bring a disparate impact claim. I mean, for pure economic reasons, because a purely disparate impact claim, there is no punitive damages available. But that being said, I mean, let's just talk about EEOC and disparate impact. If you read this guidance, it does not differentiate between what disparate impact laws. It does highlight some, but it doesn't differentiate. And when it commands the agencies, including EEOC, to take action, it doesn't talk about specific laws. We have heard anecdotally that the government is mostly looking at race and sex when they're looking at this, but by the very face of the executive order, that is not what it says. And we're seeing, like at OFCCP regs, they are taking down disparate impact, like for disability, and they have a veterans one that those are slated to be removed. Now, does it matter for EEOC? How's this going to affect them? You know, and the thing that employers should keep in mind is that many of EEOC cases and the way they tend to look at cases are pattern and practice. So that's a combination of statistics and anecdotal evidence. It's not pure disparate impact. It's both theories. But there are going to be circumstances, and you know, we're dealing with one right now where it is a pure disparate impact case, and we charge. We will have to see what happens. There is one case where the EEOC dismissed or got out of the case as a result of this executive order. And that was a case the agency filed against Sheetz, which is sort of a service gas station chain, but it was, I think, in Pennsylvania, and it was over their background check policy. So I think private plaintiffs are taking over that case, but that's an example.
One other thing to keep in mind is that in the Biden administration, they were just starting to look at AI and the issue of bias in AI, especially in hiring. And the way you would do an AI case, as I understand it, Leslie and Sarah, would be a pure disparate impact. It's not disparate treatment. It really is a disparate impact. You know, having how many people are being impacted based on their race or whatever. And I think that may be impacted by this executive order. And considering who used to be first buddy, that might be a reason why they decided that.
It's absolutely a reason why, but it was actually a twofer for this administration, because a lot of pretty conservative think tank type groups, or several, really don't believe that Congress should have, or whether they even debate whether it is in Title VII, you know, the disparate impact theory. But I think if you look at the language, it's very clear it's there. So it's still in the statute. It's still, you know, it's just not being enforced by the agencies. Exactly.
So I think it's priorities time, Sarah.
Yeah.
Yeah, actually, I think I'm going to hand this off to Leslie, actually, because I think she's going to get into these priorities, particularly with respect to religion-based discrimination.
So let's just say that EEOC priorities, before I get to that, and I know that Nita, you're going to talk about this first one, but I just wanted to say Acting Chair Lucas's priorities really line up with President Trump's priorities. Like Nita said, you can look back and you can see this. And we've already talked about some executive orders today, but we're going to talk about some other ones, such as religious liberties, DEI a little bit. They actually have a role for the EEOC chair. And Lucas has been filling those roles. So it's just important to keep that in mind, that it does align very closely. Okay, next slide.
So it's very clear this administration, as it was in Trump 1.0, very focused on protecting religious freedom. He did issue 2 executive orders, basically setting up this task force to eradicate anti-Christian bias, and Chair Lucas is on that. And then also a Religious Liberty Commission. But I think I just want to mention briefly these other two memorandums, which came out from OPM. Now, that's the Office of Personnel Management, as you know. It's the HR office, basically, for federal employees. And these two are fascinating to me. The reasonable accommodation one is interesting because one of the accommodations for religion, one way to accommodate religion is actually to allow someone to work from home, teleworking, which is interesting because they ordered everybody back to the office. So that is a fascinating, but one that while this is
Ironic, I think, is the word you're looking for,
ironic was the
Anita.
word that came to mind. Yes. But one thing to keep in mind is even though this is talking about federal workers, you are going to have a group of employees, private employers, who may start looking at these memos and thinking that they apply to them. So look at this reasonable accommodation. We've got a link. You can click right on it when you get the slides. The other one, they talk about how you do the accommodations, but I thought the other one was protecting religious expression. To me was really astonishing because they go so far as to say that employees can try and change each other's minds on their religious views when they're at work. Now, not when they're supposed to be working, but say in the lunchroom or coffee breaks and that type of thing. And they basically say you do not discipline employees for the display or use of items for religious purposes, expression by groups as long as it's not during work time, conversations including attempts to persuade others the correctness of their own religious views as long as harassment, where is the line? Leslie, you're going to help us with that in a little bit. Even directed towards members of the public, you can even try to proselytize them as long as it's not on work time and in areas that are accessible to the public. So I think that non-federal employers should take a real close look at these. And Leslie, I think you're
Yeah.
ready to talk
I
more
wanted
about
to
this.
add one little fact that you might want to highlight on that religious expression. Not just employees can proselytize, but so can managers.
Right.
It does say, if until it crosses to harassment, and that's the rub. Where is that? But we'll talk about that in a moment. Okay, next slide. Okay, so Nina mentioned those OPM memos. They came out in July, and in August we had a couple things come out of the commission. I'm just going to highlight them because, again, if you want to know where EEOC is going, you just have to kind of look at their website and know where to look for. So I'm going to go in reverse order. One was 200 days of EEOC action to protect religious freedom at work. And the second was, and that was August 22nd. The second was actually August 13th, and that was EEOC issues 3 significant federal sector appellate decisions. I will explain what that means in a minute, but religion is a big issue for Andrea Lucas, for this administration, and I've followed this issue very closely. I was very involved in the EEOC's issuance of its first compliance manual chapter on religious discrimination. There was legislation when I was labor counsel before that, and I have defended employers against claims of religious discrimination since I've been back in private practice. So I watch this issue very closely. And there's a movement, and if you take away anything from today, watch religion, because it is a big deal now. And Andrea very much believes that that religious freedom is a fundamental workplace right. It transcends workplace right. It's like a plus for the workplace, and where that's going to go, we're going to see in the future. But let's talk about what we've seen so far. So that 200 days, next slide, that 200 days talks about all these different actions that the commission has taken in the first 200 days. that of the Trump administration, and they're broken down by category: vaccine mandates, other religious accommodations. She does talk about combating anti-Semitism in universities and the Columbia settlement and serving on the task force, and protecting employees' religious rights. Now that gets me back to that guidance, that document I mentioned earlier. EEOC issues 3 significant federal appellate decisions, because those 2 decisions, normally EEOC does appellate decisions and they don't highlight them, but when they issue it like this is really Andrea taking a page out of Hy Feldblum's book. She did this when she was looking to do more on, ironically, protecting people based on LGBTQ issues. So these guidance, these documents really tell employers where she wants them to be going with religion, and some of the things that the commission is expecting. There is a vaccine case. It happened in August 2021. It was against the Treasury, I believe, and it was August 2021 is right when the federal government was trying to mandate vaccines, and there was a law enforcement officer at Federal Reserve, and he did not want the vaccine, and he was concerned. He said his religious beliefs wouldn't allow him to take vaccine because it was derived from fetal cell lines obtained through abortion. This is not a new story for any of us, but why am I highlighting it now? Well, a couple of reasons. One, in this case, EEOC, Andrea Lucas really wanted to make a point. The agency decided it could not accommodate this individual within 4 days. And they didn't really do a lot of looking to see if they could accommodate him. And this decision is worth looking into, because it talks about all the different things that the agency could have done and didn't do. And one of the things that it said the agency should have done here is it should have asked him more about the nature of his religious objection, because what did he mean by derived from fetal cells? Was it tested on it? Because there was a vaccine available at the time, according to the decision, that was just tested but not derived from. And what the decision says is that the agency had an unfair advantage. They knew this and this gentleman didn't, and it wasn't fair of them not to let him know that this was available, because he might have been interested in it, and therefore the interactive process that they didn't gauge properly and it broke down. They also talk about how quick it was, and it just makes clear that is how thoroughly they are holding employers accountable. The second decision is a VA doctor who was hired, who asked for an accommodation to attend prayer sessions on Friday afternoons. And the VA temporarily provided the doctor with the accommodation, but the problem for the VA was that Fridays are a very popular day off. And eventually it got too hard, and then they offered her several choices of schedules. Honestly, none of the schedule choices were very good. But the EEOC really took them to task in this case and said there was more they could do, there was more they could look at, and that they should have accommodated the VA doctor. And so it talks about like the documentation and what you should be looking at. And I commend you if you have these issues in your workplace, you should look at them. I wanted to mention one other case that was mentioned in this 200 days, and it was Crystal Ridge Ski Area. It was a Christian employee who the EEOC said was fired because he socially posted his religious beliefs. It was a very vague press release, so I went back and we went back, Sarah and I, because all employment lawyers are nosy at the end of the day. We wanted to know what was going on there, and what we saw is that this he worked at the ski lift. He was promoted to manager, and he used to post things, and all it says in the answer is that they were anti-gay. It doesn't give us any specifics. That they talked to him about it, and he said, well, can I still post about the Bible? And he posted something from the Bible. We don't know what. The Bible has a lot of different verses in there, but he was terminated 3 days later. He was a manager at this point, and I imagine some employees there complained. I'm not sure in the past EEOC would have picked this matter to litigate, but I will say this is social media, still a manager, own opinion on the outside. This is going to be something different. Everyone will say, oh, well, just look at your social media policy, but they may take a broader look, this administration, about what people can or can't post. So that's an area I think that everybody should be aware of. Okay.
There is a lot of right now, employers are actually looking at social media where they're being directed to look at people's social media, and people are being fired for things that they are saying on social media about some of these controversial situations that are going on. I think, Leslie, what you're pointing out as we get ready to go to the practical pointers that we're going to talk about is that this is not your old religious accommodation where you just kind of said, oh, yeah, whatever, and then said, no, this is more like, this is at least as rigorous, I think, as an ADA, sit down and conversation, don't you think?
Absolutely. Absolutely. Okay, so let's talk about some advice I have, and I have a lot of advice here. So next slide. This tension between expression versus harassment and how you get there. I mean, you really do have to respect employees' right to share in a way you never did before, or people thought. I mean, a lot of people think, oh, you can just ban religious talk in the workplace. That don't do that. You can't do that. But the question is it bothering other people? Is that a reasonable bother? I mean, if I hear Sarah talking about religion and I complain and she's not talking to me, it's probably not going to fly unless it's really disrupting my ability to work. But if someone is badgering you or, harassing, certainly that could be an issue. I always think we have to reinforce that religious expression cannot demean, pressure, exclude others. And, sometimes employees don't realize that they can, ask the person to stop. Maybe it's uncomfortable, or they could talk to their manager. The other part is the accommodation versus the business needs. You really have to assess the request individually. But, with the higher standard we now have for religion, we are no longer looking at this as a de minimis issue. To be an undue hardship under Title VII now, it's a lot harder. It's a bigger factor. It's the focus on the business. Does it affect the cost of the business for the size and nature? It's fact intensive. Look at the operations. Is that person, is that accommodation? Is the store not going to be able to open because that person isn't there? What is it going to, how is it going to affect the business? That is the most important part, and that is really what the Supreme Court stressed. And I think that we forget that, and we often look at the burden on other employees, which they tried to raise in the VA matter. And what the commission said in that is, I don't see any proof of that. How do you prove that? Like, do your employees have to quit? Like, what's it going to take? So, but realize that matters if you want to say it's an undue hardship. Consistency counts. All faiths should be treated the same. The whole rub on Title VII is that religion is not really defined, and a lot of things, as we saw in COVID, qualify as religion. Being agnostic, lots of different things. So it has to be sincerely held religious belief. And after that, anything's possible. So just be aware of that. The biggest advice on this is you have to equip your managers, because if managers don't realize the law has changed, can't recognize a request for an accommodation for religious reasons, don't take it seriously, that is where everything falls down. So equipping your managers to recognize and handle the request, to know that the world changed, is the most important thing you can do in that regard. Which brings me to the next page, which I have just a few more things I wanted to mention.
Sarah, the other way.
Next page.
There
Thank
we
you.
go.
Okay, so here are some other practical advice for employers. Look at your policy again. I know we always look at our policy, but does it spell out a clear process that employees know when they want to request a religious accommodation? When I say process, I'm in the second bullet, I am talking about your internal process, not what your employees see, but how are you going to handle these? Who is responsible? Who's not responsible? What are the steps? You know, what are the responsibilities? What are the roles? These matter because when you drop the ball on these, this is a very good chance the EEOC could, you know, move forward. So it's really important to know what you're going to do. And the tools. I mean, I really do recommend having religious accommodation forms. I wouldn't require employees to fill them out, but it's helpful. It might help them. And of course, those, you know, have to comply with the law. And on the other end, for HR, I would have a checklist of what they need to know to do a religious accommodation, or whoever is approving these or looking at these, so that they know they have enough information. And it's not a ton of information, but it always depends to decide. Also, decisions, knowing, you know, approvals and denials, and putting what is needed in writing. Training, again, I talked about managers. I can't stress this enough. And documentation is key. All that talks about repeatedly in those commission decisions, you didn't have anything proving that you went through the process. I always say this to my clients: if it's not written down, it doesn't happen in the EEOC's mind. What do? They send you an RFI. It has documents. You know, other things happen. They're just not in documents. Doesn't exist. So I can't stress that enough. And that concludes this part. Moving on.
So I think, you know,
We get to
religion
everybody's favorite
religion is a
topic of
hot
DEI.
topic, but Sarah, what's the other hot topic we need to talk about?
Of course, yet again, we touch upon DEI, but we do so because it is important to review these things, as it does remain one of the priorities. So, you know, the EEOC has issued a Q&A type document related to DEI discrimination and harassment that can occur in the workplace, and really provides this insight into what types of policies or actions would constitute illegal DEI. And so there are a few examples within this document that employers should be aware of. One would be balancing a workforce based off of the demographic makeup of personnel. That would be, you know, that potentially constitutes illegal DEI. So would staffing a project based off of client or customer preferences or requirements for diversity. DEI training, that could potentially be considered creating a hostile work environment, or employee resource groups that would limit membership to only certain protected groups. So that has been included in this document to at least provide some guidance to employers. Next slide, please, Sarah. So, you know, as Leslie has stressed today, Acting Chair Lucas has certainly reiterated her priorities and commitments publicly. And in that same daily caller interview that we referenced earlier, about how she intends to change the culture. This included holding organizations accountable for having implemented or engaged in DEI practices, particularly during the Biden administration, that would have constituted race-based discrimination. So she really shared her perspective, which you'll see these quotes here, that a lot of companies went into a memory hole with their DEI practices. And she added that the EEOC is going to exact that cost one way or the other, because the EEOC is going to remedy victims that were harmed. And I think, of course, there's going to be some limitation given the statute of limitations.
Yes.
So
if the employers have been are so sick to death of DEI, it's hopefully because you've gone back and you've reviewed your DEI policies and related practices and programs, and you've made changes to comply with these issues in this, this administration. I suspect that many of these memory hole actions will be time barred by Title VII. It has a filing requirement of 180 or 300 days after a discrete act. I'm not talking about harassment, which can continue, and pay, yes, but discrete acts, hiring, firing, all those kinds of things. So I'm not sure how many of these actions this administration will be able to get to, but if there may be charges filed already that we just haven't seen yet that they're investigating.
Well, let's go to the next slide. We talked about Lucas's her guidance that she provided a couple of months ago. I think the most important thing for employers to look at, if they have not yet, is Attorney General Bondi's July 29 memo, which basically is guidance for recipients of federal funding regarding unlawful discrimination. Now, we may not agree with everything the way she's put it, but this gives us an idea of what they consider to be violations of Title VII, for example, and things like unlawful preferential treatment based on protected characteristics. But the one that we find most interesting, and Sarah and Leslie, I'll be interested in your thoughts, is they talk about proxy discrimination, where you're using something that will get you the same result, but you're not using race. Specifically, they cite geographic, for example, people in Harlem, let's just say, we're looking for people who live in a particular area, or low income specifically is mentioned as well. That's not something we've seen before. Leslie, are you familiar with the proxy discrimination?
I think it's a new word, and it's maybe a scare tactic. That some of those things are going to be easier said than done, and we'll just have to wait and see.
But they also talk about segregation, which honestly, until Chair Lucas brought that up, I hadn't really thought about segregation. It violates Title VII. It was part of the reason they had it. But then also, training. You need to look your training. Does it stereotype? Does it exclude or disadvantage individuals based on protected characteristics, or create a hostile environment? Going to the next slide, the thing I would say that can be really helpful, and when I'm done just going over these quickly, I'd love Leslie and Sarah to comment as well. So the recommendations at the end of the document, she talks about best practices. And I think all of these are really good ways to approach. For example, ensure inclusive activity to everything, focus on skills and qualifications, prohibit demographic-driven criteria, document, back to your point, Leslie, document legitimate rationales for your decision making. Scrutinize neutral criteria for proxy effects. Wait a minute. Did I just hear statistics in that one?
You heard
Anyway.
something. I'm hearing word salad, but
Okay.
that doesn't mean we don't have to look at it. We definitely do.
Eliminate your diversity quotients, avoid exclusionary training programs. So here's an interesting one. As federal contractors back in the day, we had to roll down our non-discrimination and affirmative action obligations, but we did not have to monitor compliance. She's saying not only do you roll down your non-discrimination into third parties, you have to monitor their compliance. And then obviously anti-retaliation. So you guys have any other thoughts about those? Anything in particular?
I think this is a lot of tall order, and they're going to be difficult. And some of these are, basic things like clear anti-retaliation procedures and safe reporting mechanisms. That's, employment law 101, and, some are a lot more challenging to deal with.
Yeah, no, I think if we get to the next slide, it kind of takes
Yeah.
us to really, quite frankly, more practical advice for employers beyond, Attorney General Bondi's memo. There are certainly additional actions that employers should take regarding DEI if you haven't done so already. So first, employers should be conducting a privileged review of their DEI practices and policies, paying particular attention to supplier diversity policies. In recent years, there have been certain cases that ultimately found a violation of anti-discrimination laws with respect to supplier diversity policies. Second, the EEOC has based several of its probes into particular organizations or industries based on the information or documents that are posted publicly on websites. So employers would be remiss not to go back and review their organization's public-facing statements to ensure that they're not exposing the organization to scrutiny. Third, employers should review, as we've kept talking about, trainings that are offered to personnel so that you're ensuring they're not inadvertently containing information that employees may find unlawfully hostile. These trainings also should stress that discrimination against any protected group is prohibited. It's not limited to any specific type of protected group. And next, while employers can lawfully collect and analyze demographic data of its applicants to ensure that there is not discrimination, they should also ensure that this data isn't used in a manner that could constitute the creation of quotas or set-asides, things that would be in violation of Title VII. But lastly, for employers to consider is analyzing their promotions and their terminations, including layoffs, so that you're determining whether there are any discriminatory patterns there.
So I wanted to add something here on the training, and this was something I was just actually looking into today, and I think it's a hot tip, but maybe folks know about this. If you have a situation where an employee is refusing to participate in your, say, harassment training, and you're second guessing how to handle things, I'd reiterate to take a hard look at some of the issues that Sarah talked about, and we've said already. But also, you really need to find out from that employee why she or he is objecting to the training. What specifically are they saying is discriminatory? Because oftentimes they're saying it when they haven't seen it and they're prejudging it, and they're just, they're not happy about it. And then, and especially if the employee hasn't taken the training yet, I'd highly recommend you look at this brief that the EEOC filed in this case called Vavra versus Honeywell International. Now, this case involved an employee looking at complaining about an unconscious bias training, and this brief was filed in 2024. So you're thinking, come on, Leslie, that was filed under the Biden administration. Why do we care about this? Well, this particular brief is mentioned twice in the Q&As on DEI that were released under this administration. And basically what it has a lot of good stuff for employers, but most importantly, it says if an employee alleges that a particular training is discriminatory, such as, racially hostile environment, they really need to be able to point to particular aspects of that training. They can't just generally say it's a problem. If they can't point to the aspects of the training that they find to be discriminatory, then it's not going to, their complaint is not going to be protected. So I think it's just a helpful thing to know about. Okay.
So Leslie, I think you're up next.
Okay, well, I can go pretty quickly here because I see we're running out of time, but another issue we've started to hear about, we're going to hear a lot more about in the future, is anti-American bias. And basically, what Andrea said, what the commission is saying is, if your company is she said this to the Daily Caller, if your company is importing illegal aliens or migrant workers or visa holders and preferring them for whatever reason, bias, cost, it doesn't matter, at the expense of American workers, that is national origin discrimination. So I just named a bunch of different ways that you could get your workers. And this ties in, of course, with the president's agenda. And she has referenced this one case, Leo Palace Resort. This took place in Guam, and the company, according to EEOC, had a preference for Japanese workers over others, including American workers. They settled in February for $1.4 million. So what we're going to see is more cases like this. Whether or not it'll be under new theories, visas, whatever, things that the EEOC's never touched before, I don't know, but I would expect it. Okay.
Most discrimination cases around, immigrants versus Americans are under the Immigration Act, the
Right. DOJ.
1986, right? So this is
So-
unusual. I'm sorry, go ahead, Sarah.
Well, I was going to take us into the next topic. I didn't mean to get us off of anti-American bias,
Mhm.
but of course, want to address also sex-based discrimination or harassment. As has always been the case, the EEOC is, of course, continuing to pursue these types of claims. And we should note here, though, that Acting Chair Lucas has been vocal about her commitment to recognizing that sex is defined only by binary or biological sex, not gender identity. And in fact, the EEOC has begun halting payments to state and local agencies for their investigations into claims alleging bias by transgender employees. Of course, transgender employees can nonetheless pursue charges based on discrimination, as discriminating against somebody because of their gender identity, particularly by terminating their employment, remains unlawful sex-based discrimination under Title VII, as decided by the Supreme Court in Bostock. Next slide, please. Practical advice here is likely going to be a little short because I'm sure you all are aware and implementing these practices. But as you enter the end of the year, you're reviewing what you've got going on and want to make sure that you are compliant. There's the few things you always want to keep in mind with sex discrimination and harassment policies. So one, they should always be communicated clearly and consistently. You want to train your managers and your employees what constitutes sexual harassment, how they can report these types of concerns, and also promptly investigating or reviewing these reports, as these are the strongest methods to defend yourself in the long run. But of course, as Leslie has discussed today, employers might face some conflict between, religious beliefs of employees. And so there is guidance. You've got to accommodate them, but not at the expense of other employees where they're experiencing harassment or discrimination.
Right. All right, next slide. What to expect from EEOC moving forward. Next slide. I'm going to go quickly because we are running out of time. I think we've talked a lot about these priority issues. As I've said, in order under the quorum, there's cases EEOC hasn't been able to bring before. So if there are going to be new issues, we're going to see or new theories, those are most likely those cases. So I think we'll see cases redefining sex discrimination, cases focusing on this women's rights and segregation issues, and cases that certainly that support expanded religious rights, and cases that challenge DEI initiatives. Last slide for me. The EEOC, what are we going to see next? Okay, first thing, once they can vote again, you're going to see the criminal background check guidance. I'd be very surprised if that doesn't go very quickly. Also, you guessed, it's a guidance for EEOC. OFCCP was regulations. They have already, that's already slotted to get rid of. I'm not clear anymore. Last week I would have said, oh yes, the EEO1 report's going to go. Now I'm not so sure, but that was certainly in Project 2025. But we'll have to wait and see. EEOC is realizing, and maybe the whole federal government is realizing, as Nita pointed out, it's kind of hard to move forward if you're not, requiring employers to collect statistics. We are seeing, that EEOC has a $20 million decrease in its budget, and that is going to affect things. We might see offices close. I think we will. We'll see some of headquarters change. So the only other, I think that's everything that we really needed to cover on this. Next slide.
All right, let's go just quickly. We do have a wonderful FortneyScott resource page. We also have a insider podcast, DC Insider. We're just going to have a podcast that is going to be, you're going to be available to see it, to listen to it. And just a reminder, we're going to talk about compensation decisions with the Trump administration's new guidance, October the 23rd. And we hand it back to Sarah.
Thank you, Nita. Again, we would like to thank you all for joining us today in part one of the FortneyScott's Workplace Legal Compliance webinar series. If you have any further questions, please email us at info@fortneyscott.com. A recording of this webinar and a copy of the PowerPoint will be available to all of those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.